Court rise.
Cyril Archibold Capron, the government of Turks and Caicos Islands and the Crown.
Yes.
May it please, my lords, I appear for the appellant, Cyril Capron, with my learned friend Mr. John Ruckley and Miss Sophie Weller. Respondents represented by my learned friend Mr. Timothy Morshead. My lords, it's a privilege to appear before your lordships, and in particular, it's a privilege to appear in what I understand to be the first Privy Council matter to be heard in this fine new building. A little bit of housekeeping first, if I may. I took the liberty, my lords, of drafting a response in part to my learned friend's case over the course of the weekend, designed, I hope, to speed us along today because of the limited time that is available. May I confirm, I apprehend it is in front of my lords. I don't know whether you yet had any opportunity to look at it.
Yes, yes.
I am grateful. The other supplemental documentation is a small bundle of additional authorities that are referred to in the response document. But I'll speak to the response document in the course of my submissions. Lords, by way of introduction, in my submission there are three singular features of this case that underlie it. The first is that it concerns an agreement, the parties to which, that's to say a group of developers and the government of the Turks and Caicos Islands, both thought was legally binding upon them. So this is an entirely different type of case to the one that was under consideration by the House of Lords in the case of Cobb and Yeoman's Row. Because in that case, of course, the parties were agreed that the agreement that they were working on the basis of was binding in honour only. Secondly, the agreement, in our case, was resiled from by one of the parties, that's to say the government of the Turks and Caicos Islands, after it had changed hands in political terms. Control of the government, as you know, had passed to a party, the PNP, headed by the Premier, Michael Missick, who is now mired in allegations of corruption and venality so grave that he and his associates face criminal investigation on the recommendation of Sir Robin Owen. And of course it was he, Mr. Michael Missick, who personally orchestrated the repudiation of this agreement. The third feature of the case is, in our submission, the lamentable lack of any proper or full disclosure by the government of the Turks and Caicos Islands in the litigation in this case. Of course, this was prior to the old inquiry, prior to the suspension of direct government on the islands. That lack of proper disclosure is a matter that the Supreme Court attempted unsuccessfully to address, but that the Court of Appeal declined to even attempt to remedy. And that has prevented the appellant from ever getting even close to understanding why Mr. Missick repudiated the agreement. Those are underlying features of this case, my lords, which I apprehend will be apparent to you from the appellant's case. As you know, we put our case essentially in two ways. We say there is, in this case, a binding contract, an enforceable contract, and seek to have it enforced. In the alternative, we say that this is a case in which the doctrine of proprietary estoppel can properly be invoked. Can I deal with the points first. The question is whether there was a concluded contract between the parties with reference to the grant of a conditional purchase lease and a development agreement on the 35 acres of Crown land north of Caicos Resorts, which is also known and referred to in the documentation as Amanyara.
Well, that in fact leads me to my first question, which is, who do you say are the parties to this agreement?
The parties to the agreement are so far as the development agreement is concerned, the government of the Turks and Caicos Islands. The agreement is between the government of the Turks and Caicos Islands and the developers, my lord.
The promoters?
Yes.
Well, personally? Personally?
Yes. Oh, yes. I mean, the company wasn't in existence when the agreement was reached. The agreement was that the government of the Turks and Caicos Islands would enter into a development agreement with the promoters.
Or with the company?
Or with the company, yes.
Well, presumably with the company was the intention.
The intention was, yes, that the company would be formed, and yes, that the company would be the party to the development agreement. No.
So the only useful remedy would be specific performance.
Yes.
The damages wouldn't be.
Well, or I apprehend a declaration, my lord, would be the desired result.
Because you can't get specific performance against the...
Yes, it's a point that wasn't taken below, it is taken by my learned friend, and in fairness to him, he's entirely correct. A declaration.
As I understand it, I'm not saying you're wrong, but the government of the Turks and Caicos Islands is a separate entity from the Crown, is that right?
Yes, my lord. Yes.
That's not normally the case.
Well, if they be one and the same, my lord, then they be one and the same. Certainly all the documentation that was generated between the parties in this case appeared to proceed upon the basis that they were separate entities. But there's no doubt that the government of the Turks and Caicos Islands was charged with the task of allocating the distribution of Crown lands. When one looks at the draft agreements that were generated pursuant to the agreement between the parties, I can take you by way of example to a draft development agreement that was generated at page 418 in the record file 2, my lords. It's clearly contemplated that James Poston, Governor of Turks and Caicos Islands, acting in the name of and on behalf of the government of the Turks and Caicos Islands, will execute this agreement. But when one goes to the conditional purchase lease that would operate pursuant to this development agreement, at page 436, one sees that it was contemplated that this should be executed by James Poston, acting in the name and on behalf of Her Most Excellent Majesty Queen Elizabeth II, the Crown. Because the lands that were being allocated for development were Crown lands. So...
Yes, I follow that, but
my Lord Collins...
it's no doubt my fault, but the agreement that you're relying on is one that you, well, perhaps I'd ask you, do you suggest was made between the promoters and the Crown, or the promoters, the Crown and the government, or the promoters and the government?
The agreement that we rely on was an agreement reached between the promoters and the government, but I apprehend the correct analysis may well be that in reaching the agreement with the government was in that situation acting on behalf of itself, qua government, and on behalf of the Crown.
Well, there's an old 19th century case, I think, about New Zealand that says there's no difference between the government of a colony or then a dominion and the Crown. Well,
my Lord, I'm grateful. I don't dissent from that.
But does that not ignore the independent position of the governor as compared with the government?
Yes, it is an issue that's raised against me. In our submission, there was never any question of the governor bringing an independent mind to bear on this matter, that in terms of the allocation of Crown lands for development, he would execute these agreements on the advice of the government. The Constitution indeed provided that he would do so. The Constitution gave him, in an extreme situation, power to decline to accept the advice. But it's never been suggested, and I apprehend couldn't plausibly be suggested, that the agreement we're talking about now was one that would remotely have occasioned the governor to invoke that extreme sanction, so that for every practical purpose, the governor would approve the agreement on the advice of the government that entered into the agreement, and would do so by the execution of the development agreement, and then in due course, pursuant to the development agreement, execute the conditional purchase lease.
So what's the declaration that you're seeking? Is it formulated anywhere?
It's formulated in the amended statement of claim, my lord, which you find in bundle, the record 1. It takes page 32. And it's the alternative prayer at paragraph 12C. It mirrors the distinction that appears to be drawn in the drafts between government and Crown, but I readily accept the point my Lord Collins makes in that regard. And it is likely that it doesn't matter in the event.
And when was the agreement complete on your analysis?
But the agreement was complete by the conduct of the parties when they had done everything that was required of them by the offer letter.
And when was that? You described the offer letter as the letter of...
Well, if I can take you to the offer letter, my lords.
This is page 409, isn't it?
Yes.
The 22nd of January 2003 letter.
And
It's also at 264, isn't it?
Yeah. Yeah.
Together with a rather helpful chronological series of
That's because there was an application made for an injunction to prevent the government or the Crown disposing of the land pending the trial of this action, and it was exhibited to the affidavit sworn in support of that application. But the...
It's also at 500.
Yes, we have it in a variety of places. It's... paragraph 24 of our, if I can go to the question my Lord Clerk posed, on analysis of the offer letter of the 22nd of January 2003 that we find at page 409, it required the partners, the promoters, to do three things. And in our submission, it's on their doing of the third of those three things that they accepted by their conduct the offer contained in the letter. It's paragraph 25 of the appellant's case.
Yes, I follow that, but would I be right in thinking that on your submission, if Mr. Simons had written back on January the 23rd saying, I accept your offer, there would have been a contract at that moment?
Yes, yes. I mean, that was the evidence that the learned judge heard. The evidence that the learned judge heard was that so far as the government acting through Mr. Derek Taylor, who of course is a signatory of this letter, so far as he was concerned, on having the Executive Council having made the determination that led to him writing this letter of offer, it was an offer that was binding on the government.
To whom is the offer made?
It's made to Mr. Carlos Simons.
Well, I wonder if you look at the first paragraph.
Yes, it's a reference to the contemplated company there. He was dealing with the partners, and he was writing to Mr. Carlos Simons as the member of the partnership who was dealing with the negotiations with the government. And it was understood that the proposal of the partners was to constitute a company to be known as Northwest Projects Limited.
So it was common ground that the company hadn't yet been constituted at the moment of the letter was written. Is that right?
The documentation would suggest that, my lords. I say that because the offer letter that we see that was made on the 22nd of January 2003 was made as a result of a development proposal that the partners presented to the government. And in the development proposal, it was clear that the company, the intended vehicle for the project, had not been at that stage formed.
But no point was taken on the non-existence of the company, and this case doesn't get into all those very sophisticated distinctions between contracts with agents and with unincorporated.
No, my lord. Indeed, it's a point that I deal with in my response to my learned friend's case, that so far as all the indications in this case are that the government, it was a matter of no moment to the government whether they entered into a contract with the partners in their...
It may be relevant to the question whether the parties are to be taken to have intended to enter into legal relations if the whole context of the negotiations was that there would be a binding agreement as between the company and the government. And if it was common ground that the company didn't yet exist, then that's perhaps a pointer to the fact that the judge was right.
The document I was going to take you to, my lord, is at page 258. This is the development proposal that the partners submitted, and it was quite clear, proposal name, Northwest Projects Limited, to be incorporated. So certainly that at the time when the government received this proposal, they knew that what the partners proposed was that the project should be operated through a corporate vehicle.
But one possible inference is that all the parties ever truly intended was that there should be a binding agreement between the government and a company. At no stage do they ever intend that there should be a contract between the government and some individual.
That was, that's not a point that's ever been taken, my lord, or was ever suggested. And my submission would be that it was a matter of no matter to the government, a matter of indifference to the government, whether the partners with whom they were contracting used a corporate vehicle or not. What did matter to the government, and this again is clear from the documentation, what did matter to the government was the identity of the promoters. So the intention of the party, certainly, my lords, the intention of the government, if one goes to the letter, the earlier letter at page 255, this is a letter that precedes the development proposal we just looked at. This is Mr. Taylor writing again to Carlos Simons, proposed residential development, spoken about your group's interest in undertaking a residential development at Northwest Point. Whilst you're yet to provide all the details required for the submission to be made to Executive Council, we regard you and Mr. Hart's Capron, Hart's being the nickname for Mr. Cyril Capron, Mr. Hart's Capron, as two of our prominent belonger businessmen, and I'm impressed by the details provided on the other project principles.
The development proposal was a 57-acre site with 4 hotels, goodness knows what else.
Yes.
Which didn't feature in the later plan for 35-acre site.
No, on receipt of the development proposal, the matter went to the Executive Council and they pared it down. They certainly pared the area down significantly.
So the detail of all this, it doesn't, although you say that the offer was made on the basis of this proposal, the detail of this will form no part of any contractual factor.
What does seem to, well, my lord, what does seem to have mattered to the government, as we've seen from the letter of 10th of May 2002, that's the letter that the learned trial judge referred to as the comfort letter. What did seem to matter was the identity of the proposers. The proposal itself was in relation to the location of the proposed land is the same. It's on Northwest Point, north of, if you go to page 258, my lord, it's our group wished to develop a parcel of land in the Northwest Point area directly north of the property presently held by Caicos Resorts Limited. That's north of the area otherwise referred to, or elsewhere referred to as Amanyara. And it's the third paragraph, the approximate dimensions. It's that paragraph that they're proposing that they be allotted 57 acres in the event what they were offered was 35 acres.
So if we go back to page 264,
Oh, yes.
is the proposal in the first sentence, that relates to the 57 acres, does it? And the lease proposed in the fourth paragraph relates to a different, or at any rate less, acreage of land.
Well, the correct...
I mean, the proposal submitted is a reference back to page 258.
Yes,
so that was a proposal in relation to the 57
It was a proposal,
acres.
and
so that's a different plot.
No,
It may include the 35 acres, but it's certainly not the same acreage.
No, it's the latter that I apprehend to be the correct interpretation, my lord, that they asked for 57 acres in that location directly north of the Amanyara resort. The offer they got was for 35 acres in that area. And the 35 acres that they were offered in the offer letter then had to be surveyed. And that's also referred to.
So just help me, going back to what you describe as the offer letter. The proposal submitted by the above company is what the letter, and it's
Well, it can only, that can only,
257?
yes, 258. I mean,
Well, the 258 is
yes, 258. Well, yes, it's sent under cover of the letter of 257. My lord's entirely right. And I apprehend, my lord, a lawyer might not have expressed it in this way, because, of course, the proposal, if one, as it were, read the development proposal with a lawyer's eye, one would realise that it couldn't be a development proposal that was submitted by the company, because the company is to be incorporated.
But leaving the company point on one side, if Mr. Simons wrote back on the next day saying, I accept your offer,
Yes.
what would he have accepted?
He would have accepted the,
The offer in relation to 57 acres? Or what?
no, my lord, the offer is clear in its terms. Doesn't reflect the amount sought in the development proposal. If you go to the pre-penultimate paragraph on page 264, this is the offer letter. Executive Council has also agreed your group be offered a conditional purchase lease on 35 acres of Crown land.
But that says has also agreed.
Yes.
That doesn't suggest that it is the only offer being made, or that the whole of the offer related to the 35 acres. On the contrary, it rather suggests, just looking at the letter, that it is a separate, further proposal.
Well, the other offer, my lord, the other offer is that is necessarily implied in the first and second paragraphs, because
So in my example of Mr. Simons writing, I accept your offer.
yes.
What, if anything, has been agreed in relation to the proposal submitted, let's say the 57 acres? Is the true answer to that nothing? Is the true answer to that nothing? Because it wasn't intended that anything should be agreed until it was all set out in some formal document.
Well, it's the development agreement, my lord. What's being offered is a development agreement.
Yes, but in relation to what?
Well, plainly, my lord, it's referable to the reduced area, the conditional purchase lease, because these development projects only work if the developer is given possession of an area of land. What this letter was offering was a conditional purchase lease or a land freeze agreement, and the way those work, as I'm instructed, is that for a sum of money, the land will be effectively frozen and the developer will be allowed into occupation on the basis that at the expiration of the period of the freeze, he may then acquire the freehold. The alternative is a conditional purchase lease, which allows him into occupation as lessee, and on the completion of the development, he can then acquire the freehold.
Well, I think we'll come back to that in a moment, but I think my Lord Clerk is pointing out that the first paragraph of this letter,
Yes.
leave aside the possible difficulty with its reference to a non-existent company,
Yes.
approved in principle a proposal submitted, which you're telling us is to be found at page 258,
Yes.
cannot mean approved, because that proposal was 58 acres, and if you look further down the letter, you'll find what is being offered is 35 acres.
Yes.
You've consistently pleaded that the agreement was to provide two things. Firstly, a development agreement, and secondly, the conditional purchase lease.
Yes.
So you say there are two matters which are the subject of agreement as a result of this letter.
Yes. That there be a development agreement, necessarily, we say, referable to the reduced acreage, the 35 acres. Well, that's the effect of the decision that has led to this letter. The Executive Council has determined to allot not 57 but 35 acres to this group.
Well, you wouldn't guess that reading the offer letter, would you? Mr. Simons writes back, I agree. And then there's a dispute as to what it means. If we were just looking at the letter, together with its context, namely the 258, you wouldn't guess that they were only offering 35 acres, would you? You'd think they were offering both.
Well, my lord, if one examined what's sometimes called the factual matrix, the way in which these arrangements worked in practice throughout the island, one readily appreciates that the acreage that was being offered by way of conditional purchase or land freeze agreement that is the land that would be the subject of a development agreement. It would, in a sense, my lord, and without wishing for a moment to be flippant about it, it would make a nonsense of this letter if the proposed development agreement was thought to refer to anything else. Certainly the parties didn't understand it as referring. They knew that it was apparent that the 57 acres wasn't going to come their way.
Well, that's the way you've pleaded it always.
Yes.
I think you may wish to say, do you not, that the agreement in principle to the proposal was an agreement to the project without getting into the level of detail about the acreage.
Yes. Oh, just so, my lord. And it was also, of course, necessarily implicit from this offer that the proposal would have to be reworked. The proposal that had been submitted was referable to 57 acres. Well, you can not get as much building work on 57 acres as you can't get as much on 35 as you can on 57. So obviously the plans as to what the development was going to involve would have to change, and that's why in the penultimate paragraph on page 264, Executive Council has also agreed that your group prepare a detailed project proposal and submit to TC Invest for review. Obviously the outline project proposal contained in the document sent on the 15th of August would no longer be appropriate. So I respectfully urge the committee in interpreting this offer letter to appreciate that it's obviously not a letter that was drafted by a lawyer. It was drafted by no less a person than the Chief Minister, following a decision in the Executive Council, but that it was readily comprehensible to the recipients of this letter, and there was no doubt what the Executive Council was proposing by this offer. Had it been accepted, had Mr. Simons written back and said, yes, I accept, then it would have, there were three important things that the group had to do pursuant to the terms of this letter. We've sought to summarise them in paragraph 25 of our case. They have to prepare a detailed project proposal and submit the same to TCS for review. That would lead to the drafting of the development agreement. When the same had been prepared, the partners had to review it. And it was left to them to elect between a conditional purchase lease and a land freeze agreement in respect of the 35 acres. It's also the case that they were expected to pay the requisite survey fee. And that is not referred to in the letter, but it was the trial judge found that it was understood between the parties that that is what would happen. That was what happened in these cases. If land was allotted to a developer, what they call raw land, it would have to be surveyed, and it was the developer who would pay for the cost of the survey, and that's precisely what happened in this case.
Just going through those three things, it's for the proposers to prepare the detailed project, is that right?
Yes, my lord.
And could that be rejected by TC Invest or other government bodies?
Yes, it's submitted to TC Invest for review, and there's no reason to doubt that if TC Invest thought it an entirely inappropriate proposal, that they could say, no, that isn't acceptable, and something else would have to be prepared.
So that so far as the project proposal was concerned, that would have to be a proposal that found favour in effect with the government.
Yes, yes.
And so the government, for any reason, could say, well, we don't like any of your proposals at all.
Well, I wouldn't, with respect, my lord, agree that it could be for any reason. In my submission, when an agreement such as this is constituted, in actual fact, that's not this case, because in this case, the offer letter wasn't accepted before those three conditions were met. What happened in this case was that the partners complied with those three conditions, so that the project proposal, the detailed project proposal that was submitted to TC...
Well, I follow that, but that doesn't really matter on the basis of what is at least your first submission, that this letter was an offer letter capable of acceptance.
Yes.
How it was accepted is your second question.
Yes.
But your first proposition is it was open for acceptance, and so to simplify it, we asked the question, if Mr. Simons had written back the next day and said, I accept, your case depends upon saying, yes, at that moment there would have been a contract.
Yes, yes.
Just to go to the second of your points that you make on paragraph 25, to review a development agreement when the same had been prepared, that's for the partners to do, as I understand it.
Yes, that's right, my lord.
Were they bound to accept any development agreement that the government decided to put forward?
Yes, any reasonable development agreement that was put forward. The fact is, these agreements were in a very standardised form. One could predict what the form of the development agreement would be. One could predict what the form of a conditional purchase agreement would be. There were matters to be inserted, such as purchase price, rental. All of those matters were calculated with reference to policy and hinged upon a valuation undertaken by the government's Land and Surveys Department.
So are we into that old area of law of difference between subject to contract and subject to formal contract?
No, my lord. In our submission, the acceptance of this agreement entitled the proposers of this project to the benefit of a development agreement. Now, for review in that context, it means to check that there are not errors in it. And that was important. There were two draft development agreements generated, and they both contained howlers. Indeed, it might be the case that the latter one was not even intended to be referable to this project. But certainly, so far as the first one was concerned, it contained some serious factual errors, which, on behalf of the partners, Mr. Simons identified and promptly wrote back to TC Invest explaining. So but the notion that which I think is very much the way my learned friend seeks to put his case, that for review implied negotiation, falls very far wide of the mark in our submission. There would be no, it would not be open to the developers to actively negotiate the terms of the development agreement or the conditional purchase lease. They would be in the standard form. They would get what they would get.
Could we just look at the third of those matters in paragraph 29 of your case? To elect between a conditional purchase lease and a land freeze agreement.
Yes.
So the letter it gives the promoters the option to choose between one of the two.
Yes, it does, my lord.
Why can't it be read that it's the government who can say, well, we're going to offer you land freeze agreement, or we're going to offer you a lease. Why is the option one that can be exercised by the promoters rather than the government? Says that the Executive Council has agreed that your group be offered a conditional purchase lease or a land freeze agreement.
Yes. My Lord's absolutely right. There is a theoretical ambiguity there. It wasn't understood as an ambiguity by either of the parties. Again, this goes to the way, if you will, the matrix of these matters. It was commonly understood that it was the developers who would decide which way they wanted to go if they were offered that option. And indeed, what happened in the case is that in due course, Mr. Simons elected for a conditional purchase lease, and matters proceeded on that basis. It was not said. It was not said. No, that's not your. It's not your choice. We'll decide. It was accepted that that was a matter for him. But I do see how, in theory, there is an ambiguity in the way that the offer letter was worded, my lord.
On the basis that Mr. Simons has got the right to elect between a conditional purchase lease and a land freeze agreement, when do you say he made that election?
He made that election, my lord, when he responded to the draft development agreement that was produced by Mr. Darceau. And one finds that at it comes under cover. Perhaps I should just, before we get to it, one sees the detailed project proposal that was submitted, because until the group had submitted their detailed project proposal, it wasn't open to TC Invest to draft the development agreement. So the sequence is the land is surveyed and valued, and the survey paid for by the proposers. We see at 268 and 269 the evidence of that. The survey being obviously at 268.
What's the relevance of this being valued as commercial land when it was hotels and residential development? I mean, are they stuck with the price for commercial land, or what?
My understanding is, my lord, the land, if it's to be, it's a planning matter, I apprehend, and so if the land is to be used for residential use, it is less valuable than if it is.
Well, that's what I thought.
Yes, but this was very much a commercial project, and it was valued as such for sale to the development to the developers. So Mr. Hoser valued it at $3.5 million. Giving evidence at the trial, he said that what he was doing was ascertaining in his opinion, the open market value of the land. But of course, he couldn't do that until it had been surveyed. That had happened, as we see with the letter at 268 on the 16th of April, 2003. And payment for that survey evidenced at 267. And it was very clear to all those concerned what was happening here, because if one looks at the heading of the letter of the 16th of April, it's Re Northwest Projects Limited, registered parcel number for 35 acres of land approved for lease to the company.
Sorry, which page are we looking at?
I'm sorry, I was looking at 268, my lord. I'm coming to where my lord asked me to go, but I thought it would be helpful if we just took in the various steps along the way, briefly.
Yes.
And then the next thing that has to be done is the detailed project proposal has to be prepared and submitted. And that is done, we see it goes out under cover of the letter of the 26th of June 2003. Sorry, no, that's a bad reference.
Well, it's asked for at
30th
page
of June.
271, isn't it?
It's 281, my lord. It's the letter of the 30th of June 2003. Mr. Simons to Richard Bean at TC Invest.
But that was in the context of the request at page 271, wasn't it, for a detailed project proposal?
Just so, which is of course referable to what was contained in the offer letter, the requirement that a detailed project proposal be submitted by the developers. And that letter that my lord's helpfully identified at 271 gives an indication of what should be in the detailed project proposal.
Well, there's a list at page 272 and 273.
Yes. Yes, that's right, their checklist. Information request required from TC Invest. Now, the response to that, as I say, the letter from Mr. Simons of the 30th of June 2003 at page 281. What it contained is to be found at pages 276 and 277. Unhelpfully the wrong way around, I'm afraid, but if one put them, as it were, the other way round, one would see that it was a plan with the beach and the lot and drawings of what was proposed to be built on that 35-acre lot. Then there is the letter from 278, the letter from the architects describing the proposed project, the 110-room condominium hotel along the beachfront, 12 oceanfront villas, and that the property at the rear of the site will be developed as a high-end residential area. And then in terms of the phasing, time requirements and costs of the proposed project, those are set out on page 279. There's also at page 280 the anticipated gross revenue.
Are these in US dollars or some other country?
US dollars, my lord, yeah. In fact, the information set out at 280 is not something that TC Invest had requested or required, but it was set out anyway.
Yes, just going to 281. Have we got to the acceptance of what you describe as an offer yet?
No, my lord. On our case, the acceptance of the offer came when the draft development agreement was reviewed.
So up to this moment, the government could say we've changed our mind.
Yes. Because there hadn't been any expression of acceptance, and the conduct that was required by the offer was not yet fully accomplished on the part of the proposers. So they couldn't be heard to say we've accepted it by conduct. There was more they had to do.
Well, I suppose it would depend whether these were conditions defeasant or not.
So the letter of 281 that our Lord Savile referred to, we see the detailed development proposal is sent. We trust this is satisfactory. Look forward to receipt of the draft development agreement at your earliest convenience for our consideration. So what was happening here in our submission was that the detailed development proposals were being put to TC Invest for review. And if TC Invest had any requirements or concerns about any aspect of it, it was open to TC Invest to communicate them to the developers. In the event, no concerns or disagreements were expressed by TC Invest, and as we'll see, these proposals were incorporated in draft agreements. So that
So when you say an unequivocal election between the purchase lease and the land freeze agreement took
I'm
place,
sorry, my lord.
when do you say the election between the conditional purchase lease and the land freeze?
I was coming to that. It's when the promoters review the draft development agreement. It's obviously something that is not. It would have been helpful if it had been communicated at the same time as the detailed development proposal. But in the event, I apprehend it wasn't, it was overlooked. And
So the next stage then is what?
the next stage is the TC Invest produce the draft development agreement, and that comes eventually on the 10th of September 2003, if my lord goes to page 291, from Mr. Robert Darceau, General Counsel at TC Invest.
I'm sorry, page number?
I'm sorry, 291, my lord.
So on your analysis, if Mr. Mizik by this time was in power, was he?
He was,
So
yes.
he could lawfully have withdrawn up to this moment, on your analysis.
Yes, yes. Yes, he took power in August of 2003.
Just help me. This letter you're referring is to 291.
Yes.
Is this the moment of a contract?
In my submission, my lord, the moment of the contract is, no, the contract comes a month later at
Yes.
313, 15th of October 2003, when Carlos Simons wrote back to TC Invest, having reviewed the draft development agreement. Because once he had done that, there was nothing left for him to do, pursuant to the terms of the offer letter. But,
So that's page 313, is it?
yes, my lord. Now,
Right. So this is where he says, I have the following preliminary comments upon the draft agreement.
yes.
You say that is enough to conclude the contract.
Well, he has reviewed.
He writes a letter saying, I've got some preliminary comments, and that's it. That's your case, is it?
Well, yes, no, he had reviewed the development agreement. Now, there were a lot of mistakes in the development agreement. so that there's no question but that a further draft would have to be produced. And Mr. Simon...
What sort of mistakes?
Well, quite important mistakes, in fact. If one goes to the draft development agreement, to page, you see it begins at 293, my lord, the draft that he was sent by Mr. Darceau. And if one goes to 297, 1.1.13, Mr. Darceau has got the acreage wrong.
Well, yes, you say wrong. I see what you mean. You mean not in accordance with the letter of which you say contains the offer. But,
Yes.
In theory, at least, at this stage, the government could change its offer. Because they're not bound at this stage, are they, on your own case? No, I know that may sound artificial, but when you say there was a mistake in the draft agreement, that's entirely possible, but it's not, since the government wasn't bound at all at this stage, because it could withdraw its offer on your case, it could equally well have been, well, the government had decided to be more generous to these promoters than had previously been the case.
Yes.
Because the valuation had been from 35 acres, hadn't it? Yes.
The value, just so, my lord. If one goes, actually, just to remind ourselves, it's pages 268 and 269. It's not only, as my Lord Kerr points out, that the valuation had been on the 35 acres, but of course the survey had been in respect of the 35 acres. That's the survey that we see at page 268. And it had been registered as a discrete parcel of land, registered with the number 60,000/99. So it had its own title number. And why one can say, to answer my Lord Savile's point, that it's a mistake is at page 297, the parcel number 60,000/99 is correctly identified in the draft development agreement at 1.1.13. So Mr. Darceau's got the parcel, well, parcel 60,000/99 is a registered parcel extending to 35 acres.
It is forming part of the parcel.
Yes, well,
Is it your case that the entirety of the parcel is 35 acres?
yeah, it is. The entirety of the parcel is 35 acres. The parcel in question is the parcel that was surveyed by Mr. Leroy Charles and registered, and that's what he speaks to in the letter, his letter of the 16th of April at 268.
But in any event, Mr. Simons points out the error on 314, and Senior Crown Counsel writes on 316 to say the draft is not correct.
Yes. Yes. Yes.
And then he says, once I have complete instructions, I'll send you a fresh draft.
Yes.
But on your analysis, there's already a binding agreement.
There's a binding agreement.
There's something very odd about that. I mean, you might be right.
Well,
It doesn't seem at all obvious if we're trying to find when the parties reached an agreement which was binding between them. You've chosen a moment halfway through the discussion on the draft development agreement.
Well,
I
my
mean,
lord,
you might be right, but it just doesn't seem very likely.
And also, if I'm correctly following your submission, that it's on receipt of the October the 15th letter and draft agreement, it does seem a bit odd, doesn't it, that you say, well, at that moment, both parties were bound, that moment being the submission of a document which didn't, in fact, carry through what had been discussed earlier for the very reasons we've gone into, namely that it contained, among other things, a serious misstatement of the size of the land that was being talked about. It does seem a bit odd, doesn't it, that is the moment when you've got a deal.
Well, it's a question, my lord, of when was the conduct of the partners sufficiently unequivocal as to constitute acceptance of the offer that had been made? And in our submission, by the time this draft development agreement, I apprehend if the partners had refused to consider it, they would have been hard put to say, well, you've accepted by conduct the offer that was made to you by Executive Council. The offer that was made them by Executive Council bound them to review the draft development agreement. Well, they duly did that. The short point is, my lords, by the time this draft development agreement was reviewed by Mr. Carlos Simons, the promoters had done everything expected of them in the offer letter. And that's not to say there wasn't more to be done, but by that time in our submission, they had unequivocally, by their conduct, accepted the offer that was being made to them.
So the critical question then is the conduct by the partners of the review. Is that right? And you say that had been completed to a point which brought the agreement into existence. But now, what does Mr. Simons mean by the statement preliminary comments? I have the following preliminary comments.
Well, I apprehend, my lord, what he is doing is stating the obvious, that there are howlers in the draft development agreement that are going to have to be put right.
But does it not signify also an intention to conduct a further review?
Yes. Yes, it must go without saying that the further draft that was necessitated would have to be reviewed.
Well then, where does that leave your argument that a review sufficient to bring into existence the contract had taken place when, as is clear, a further review was going to be required?
The review, in our submission, the review contemplated in the offer letter, my lord, shouldn't be understood as meaning the final review.
How does one judge whether a review sufficient to bring into existence the contract has taken place? What's the yardstick by which that's measured?
Well, just this, my lord, that a development agreement was produced as promised in the offer letter, and it was reviewed.
So any review, even of the most preliminary or cursory nature, would be sufficient to...
Yes, well, if you will, my lord, what the letter of from Mr. Simons of the 15th of October evinces is the enthusiasm of the proposers of the project to engage with the process of finalising the necessary documentation. They had a very limited role to play in it. But what they did have to do, for example, is provide the details of the project, which they had done. They had to, but we know they had to have the land surveyed. We know they had to elect between a conditional purchase lease and a land freeze agreement. These are all matters that have been achieved by the date of this review. Indeed, as we see in the letter of the 15th of October 2003, at point 2, that the letter of the 22nd of January 2003 offered a conditional purchase lease or a land freeze agreement, we'd prefer to proceed directly to a conditional purchase lease. And it's in that context.
Yes, that's because 291, the September the 10th letter, the writer was offering Mr. Simons the choice between land freeze or what's described as a option agreement.
Yes.
But I notice Mr. Simons writes back in effect saying what's meant by the option property.
Yes, he didn't understand it. It may be that Mr. Darceau, when he used the word, the term option agreement, was referring to a conditional purchase lease, but it wasn't clear to Mr. Simons. That's why, in his response at paragraph number 2.
But the draft that was, which class of agreement was the draft that had been submitted?
The draft that's submitted had neither.
Well, the letter going with it says it has a land freeze agreement. Or does it?
No, it doesn't.
Paragraph 2 of the letter of 10th of September 291. You will note we've made provision for an option agreement. Please see clauses 1114 and 1115. Approval has been granted for a land freeze agreement.
Yes.
Kindly advise if you prefer to proceed with a land freeze agreement or directly to an option agreement.
I think,
It's curious, isn't it? Because if you look at the actual agreement, the Schedule 1, which is the what the agreement said to be about, Phase 2 talks about the option property. So there seems to be some property which is option property and some property which is not option property.
yeah.
And if we had Schedule 3, we'd know what the option agreement was. But it's only a draft.
Yes, that's right. But when one looks at the information in Schedule 1, it's been essentially derived from the information provided in terms of, for the detailed project proposal at page 279.
Mr. Matthias, I've been looking at the draft agreement which was produced in January 2004 by the Attorney General's Chambers, which has lots and lots of clauses which don't appear in this first draft. Things about training belongers and producing a plan and goodness knows what else, and obligations to complete phases at different times, and
Yes.
all dependent on detailed planning permission. You say that the government weren't limited to proper a draft agreement with a whole lot of different terms which weren't in this original draft?
Yes, the finalisation of the development agreement would be determined by the government.
But and this is the Mark II development agreement had a lot of obligations on the developers which weren't in Mark I.
No, that's right. And
So what were the developers bound by contract to agree to any draft development agreement, Mark III, Mark IV, more oppressive, they're bound by contract to accept it?
well, my lord, the draft development agreement, yes, they were standard form agreements.
Well, as I say, we're looking at a new agreement being produced in January 2004, which has lots of clauses which weren't in the original one.
The one my lord is looking at now.
It starts at
322,
321.
321, yes.
And there's email at 3:20.
Yes,
Showing
and
that this is the terms are being considered within government.
it's if you go to 334, my lord, which is Schedule 1 to this agreement, it's referable to a different parcel of land.
Yeah.
And the reason why the promoters didn't respond to this development agreement was because they understood it to be not referable to their project.
But if government had come back with a draft development agreement with these new clauses, for instance, referring to belongers and the obligation to prepare a training plan,
Yes.
in relation to the 35 acres,
Yes.
would you say that the government was entitled to pile on more obligations?
So, in as much as those obligations were standard for developments of this kind.
Is a new government not entitled to review policy and include new obligations,
Yes.
so long as the agreement is still in draft and under negotiation?
Yes. So far as the developers were concerned, the precise terms of the development agreement would be what were stipulated by the government. There was no, it was never contemplated that they would be in a position to negotiate.
Well, that's not quite true, is it? Because we saw on page 313 and 314, they made what they described as preliminary agreements, which presumably they were going to be negotiated. And then we have page 316, which we looked at.
Yes.
The response, he says, we made a mistake. Once I have complete instructions, I'll send you a fresh draft. Then on page 317, we have Mr. Simon coming back immediately, well, after the Attorney General's holiday. Soon we're allowed it back at your desk. I should be grateful to receive a draft development agreement for our consideration.
Yes.
So what he's then contemplating is a fresh draft for the promoters to consider,
Yes.
to review.
Yes.
You say that by this time the contract is already crystallised.
Yes. Yes.
You said you wouldn't get that idea out of page 317, would you? As far as I can see, you get it out entirely out of the words to prepare a development agreement for your review on page 264.
Yes.
Otherwise, one might have thought the whole point of a review was that the one side reviews it, puts their comments to the other side, who again review the comments, and eventually they reach an agreement. And
Yes.
It's only when they ultimately reach the agreement that there's an agreement. Otherwise, it's all a process of review. So the more difficult, in my mind, is that you simply can't get your cut-off approach from page 264.
Well,
You have to get it out of. Will be requested to prepare a development agreement for your review.
yes. The developers' approach in their case is that there was no question of them being able to negotiate the terms of a development agreement.
What were they doing on page 313 and 314?
They were essentially pointing out errors.
Well, that's what the negotiation process involves or includes.
Well,
Because we all know that all draft contracts have things you can comment upon. There may be errors.
well, errors, for example, as to the area of the land in question.
But point 4 on 313 is definitely a process of negotiation, isn't it?
Yes, that was certainly a proposal, but there's no suggestion that ultimately they would be able to negotiate different terms than those that the government were prepared to impose. It's
Well, where do you get that idea from?
that was the evidence at the trial, my lord. The evidence at the trial from Mr. Taylor.
What Mr. Taylor thought in his bath is neither here nor there. We're only interested in things that cross the line between the parties, aren't we?
No. With respect, my lord, what he was saying was that the agreements, the development agreement, the conditional purchase agreement, these were standard form agreements. These were not agreements that were, in any sense, up for negotiation. And that was the understanding of the parties. and that there would come a point when they evinced acceptance of the offer, when they were bound to take, and the government were bound to grant, a development agreement in standard form.
Now, you say that that moment had come apparently before page 317, but assuming that were wrong, what happened after page 317? Did Mr. Simons... What's the next letter from Mr. Simons to the government after page 317?
He receives...
Because at this moment, he's expecting to have a fresh draft
Yes.
for consideration
Yes.
and review, and no doubt, whatever you say, discussion. Because there's not much point in reviewing a document unless you can review it and make some sensible suggestions.
Yes.
So that's what it looks as if the parties then intended, a further review. So for my part, I'd just like to see what then happened.
Well, 319 he asks again.
Yes, and then he receives on the 15th of January 2004 from a lady called Rhonda Lee Braithwaite at the Attorney General's chambers a further development agreement, and that's the development agreement that my Lord Sir Henry Brooke referred me to a moment ago, and that was referable to a different parcel of land.
If it had referred to the correct parcel of land, would the partners have been at liberty to review it?
Oh, yes, for example, if you see, take for example, if you go to page 344, my Lord, which is Schedule 4 to this development agreement. This is a draft of the conditional purchase lease. If you look at the demised premises, not only has she got the, is she referring to a different registered title, but she's referring to 57 acres.
Yes, quite. But if I've understood your submission earlier, it was the conduct of the review that caused the contract to crystallise. Now, if they were entitled to review again later, how can it be said that the contract had come into existence?
Well, my Lord, I apprehend it depends on the question of whether there was anything further for them to agree. It turns upon our submission that it was not open to the partners thereafter to dissent from the terms of the development agreement and the conditional purchase lease that the government provided them with.
Is the parcel of land in the development agreement at 321 and following the proposal to move to the south, is that which ultimately ended
Yes.
the
Yes, you can.
proposal, which
Yes.
you see on 359?
Yes, if you.
On 359, Mr. Simon says, I regret that a move to the south can't be accommodated at this stage, and that's what caused the whole thing to
Yes.
to fail.
Yes. It's.
May not matter now, but if that's right, there's really nothing following the original development agreement which Mr. Simons said was full of errors, and his request for a further one before the project failed.
Well, no, because we say in breach of the agreement, a further draft was not forthcoming. They never did produce a further draft of the development agreement or a draft conditional purchase lease referable to the 35 acres on the registered plot 60,000/99. And it would appear that in January of
Do we have a plan showing us where these two parcels are? I mean, is it common ground that reference 6000/100 is the southern land? Or is it just well, I see the other side nodding, so it obviously is.
Yes.
According to the agreed statement of facts, page 8, paragraph 24, this is land, a parcel located to the south of Caicos resorts.
Yeah.
Not the land had been agreed, no interest to the partners. The beach was what Mr. Kitch called Ironshore, very rocky, and the land had sliners behind it. So this is totally different land, even though the Attorney General's chambers are producing exactly the same schedule of the timetable for the work.
Yes. If you get the map we've got conveniently to hand is at 395 in this bundle. This is subsequently when a parcel of 11 acres, a parcel of 10 acres was being offered, and if you look at the map on the reverse side of that letter, that's in my version of the record, it's 395. I suppose it should be 395B. But if my lords see the map there, there's an indication of the area called Amanyara, and that's marked with an arrow. My lords, there's a shaded area immediately to the north of Amanyara, and the shaded area, the square-shaped area immediately to the north of Amanyara that is shaded, is the 35 acres. That is 60,000. That was the plot registered as 60,000/99. The plot that was at this time being offered to Mr. Carlos Simons personally is to the south of Amanyara, and it's identified. Do my lord see the plot 11? In those rather small rectangular plots to the south. And yes, my Lord Sir Henry Brooke's absolutely right that at the trial there was evidence which the learned judge accepted to the effect that 60,000/100 was located also to the south of Amanyara and was as Mr. Kitch described as Ironshore, and it was of no interest to them.
But you're not claiming damages, you're claiming a declaration that the government is bound to do something or other.
Yes.
What form of development agreement?
Sorry, Madam.
What form of development agreement is the government bound to proceed with?
A development agreement in the standard form.
Even though we see the standard form changing in the drafts we're looking at, even if they refer to a different part.
Yes. Well, it's a development agreement that would be standard at the time.
Do you have a standard?
Which time?
Do you have a copy of a standard form?
I don't, my lord, no. But there can be no doubt that there were the version that the answer may well be that the version that Mr. Darceau sent through was the standard form in July of 2003. I apprehend that is the case. And by the time Ronderley Braithwaite sent a development agreement through in January of 2004, the standard form had changed. But indeed, I mean, if one looks at the two, one can see that the version that Ms. Braithwaite sent through in January of 2004 is a development, really, of the version that Mr. Darceau sent through. It's the same essential agreement with some added clauses, as my lord has helpfully pointed out.
At what time is the standard form? Is it the standard form? It's not mentioned in the original letter of January 2003. The standard form in January 2003, standard form in July 2003, standard form in January 2004, standard form after the government has changed its policy for disposal of crown land in March 2004. When?
it would be at October 2003 when the partners responded by reviewing the version that had been sent through by Mr. Darceau.
Just help me. The moment you suggest there is a concluded contract is what, on receipt of the draft development agreement by Mr. Simons, or on the dispatch of his letter, or on the receipt of his letter back to the Chief Executive? I'm not quite clear where you
It's on.
put the moment. That's it. There is a deal.
To put the, well, my lord, it would be with reference to his letter of the 15th of October 2003, which is at page 313 in the bundle.
What, on delivery of it?
That's what I'm asking.
Yes.
When that letter is received by the government.
Yes.
Yes, I just wasn't clear whether it was a moment before then. So he writes back in these terms, page 313, which, in effect, isn't it, you're saying this amounts, this is my acceptance of your offer.
Yes. And it was at that point in our submission that there was a binding obligation on the government to produce a development agreement for signature by the parties, and the way it would work is the conditional purchase lease would be a schedule to that agreement, and the conditional purchase lease would be executed on the grant of planning permission in respect of the site.
That way of putting it does depend upon there being, in effect, some form of standard.
Yes.
Some form of standard lease.
Yes.
I'm sure it's far too open, isn't it?
Oh yes, no, my lord's absolutely right. It is entirely dependent upon there being a standard form. But the evidence at the trial was that these documents were in standard form.
Well, not these particular ones, but some other one. Because we've got two different forms here.
No, but I apprehend the reason for that, my lord, is the time lag between the two. And as my lord Sir Henry Brooke supposed entirely rightly in my submission, these documents change over time, not least because there'd been a change of government. But I apprehend that they would go through various stages of development absent a change of government in the way that such things do.
So this is the standard form when?
This is the standard form as at, it would be as at October 2003. It's, it is in all probability the standard form used by Mr. Darceau. It's not, it's nobody.
Sorry, which is that, page 295?
Yes. I mean, I'm sure nobody would suppose for one moment that this was original draftsmanship by Mr. Darceau. This was a standard form development agreement. And if one had any doubt about that, of course, one can look at the later version and see how it's just really a development of this standard form. It's got some additional clauses.
The difficulty about this whole notion of standard form is you don't get any of that out of the original letter, offer letter, do you? This notion of a standard form.
Oh, no, no, the word standard form aren't in the letter, but there's a reference to, with capital letters, development agreement and conditional purchase lease. And the evidence of Mr. Taylor at the trial was to the effect that those are documents in standard form. But I apprehend that's no more than what one would expect in this situation. If you go, for example, to this is not if you, just by way of example, this is picking up on the point made by my Lord Sir Henry Brooke, if you go to page 300, looking at the Darceau draft, you'll see what was being said there about belongers, and you'll see 3.1.1 and 3.1.2 obliging the developer to give preference to the employment of belongers in the development project. And then if one goes to 328, one sees how that concept has been rather has been further elaborated.
Your argument resolves to this, does it not, that as soon as the letter was received, that's the letter of the 15th of October, the government was bound to enter in a development agreement in the then current standard form.
Yes.
Let us suppose, just to take an absurd example, that the letter was received on the 16th of October and the standard form was changed on the 17th. Do you say that the government would be bound to enter an agreement in the standard form that existed on the 15th?
No, my lord, I wouldn't say that.
So it would be entitled then to change to the new standard form.
Yes, there would have to be obviously a reasonable time to submit the development agreement, and it would be at the time when it was submitted to the partners, it would be the development agreement that was operative at that time.
Well, you'd have to say, though, that there could not be any substantial difference. Otherwise, how could the letter of the 22nd of January give rise to a contract when the development agreement was received?
Well, my lord, the reality, this isn't an arrangement such as one would find between commercial men for the transfer of lands, where, in a sense, almost everything is up for negotiation. This is always going to be a transaction that depended upon a grant in standard form to these developers whose project proposal had been accepted. And yes, suppose the draft development agreement may well have been adapted and developed by TC Invest and the Attorney General's chambers between the date of the offer and the date when it was submitted for execution by the partners. But that was something that they had no choice about, no input on.
Mr. Matthias, 264, January 22nd, the Attorney General's chambers were requested to prepare a development agreement for your review. What turned up was a development agreement produced by Mr. Darko, who had recently joined TC Invest. And one of the points being made in the autumn was that the agreement that Mr. Darko sent wasn't right. It hadn't been prepared in the Attorney General's chambers, and it needed straightening out. So does the contractual obligation on 264, or potential one, mean that the development agreement could be returned by the Attorney General's chambers, could be produced by an incompetent new lawyer in TC Invest, could be produced by somebody purporting to be acting in some capacity or other, as opposed to the Attorney General's chambers, which is set out in 264.
Well, there's no evidence that the identity of Mr. Darceau, who signs off his letter as General Counsel, trouble.
Page 607 shows who he is.
Sorry, which page, my lord?
Page 607, his witness statement.
Oh, yes. Oh, yes. No, my lord's absolutely right about who he is. There's no question. But if one looks at his letter of the 10th of September, page 291, page 292, he signs the letter as General Counsel, and the draft that was emailed, which we see at page 293, indicates Attorney General's Chambers.
That's how he drafted it.
Well, whose note paper?
He was told to complete the file as best he could. But when one, considering the standard form, this was a standard form which was knocking around in TC Invest.
Yes.
But when Ms. Marsha Cummings came on the scene,
Yes.
They said there are a lot of errors, and this wasn't prepared in Chambers.
Yes.
Whose note paper was page 291 sent on?
I don't know, my lord, but I would be speculating. I mean, one sees the letter at page 316 from Marsha Cummings at the Attorney General's Chambers.
No.
But the draft that was sent by Mr. Darceau gave the appearance of being the Attorney General's Chambers draft. When one looks at page 293.
The follows the letter, however cockeyed the standard agreement or alleged standard agreement produced by Mr. Darceau and TC Invest, as soon as you reviewed it, the government was bound by it.
Yes, my lord, that was the partners evincing in clear terms their acceptance of the offer.
It hadn't been prepared by the Attorney General's Chambers, which was one of the part of what you could say is an offer on the January 22nd.
Well, its provenance is not clear, but certainly on receipt, when Mr. Simons received it, it must for all the world have appeared to him as being the work of the Attorney General's Chambers. Because I say that because of the way the fronter's sheet was worded. You see on page 293. And Mr. Darceau, General Counsel, as my lord rightly says, who was at that time employed by TC Invest, was not at the Attorney General's Chambers. There's nothing in the letter that he sends, the letter of the 10th of September, to indicate that the provenance of the draft agreement was in any way irregular. In my submission, it would have appeared to the recipient of the letter and the draft that it emanated from the Chambers. It would also appear that it is a standard form as drafted by the Chambers.
But what I don't follow about this is that if the development agreement was going to be sent to the promoters for your review, what is it that they are bound by? Suppose they set out a whole series of review points.
Yes.
Now, and suppose those review points are different from the draft which they're reviewing. Now, which of those, which terms are the parties bound by?
Ultimately,
The ones proposed by the Attorney General, the ones as reviewed by the promoter, or some third and completely different document, namely some sort of standard agreement.
Well, the
Now,
promoters...
what's the answer to that on your case?
Can I say something different, my lord? Because
Just answer the question, then you can say what you like.
no, but the options my lord gives me don't accord with the promoter's case, because the promoter's case is that they would have taken the development agreement given to them.
But they didn't do that, they reviewed them.
Yes, they
See
would
page-
review, invited to review and would review, but ultimately they accepted that they would have to take the development agreement that at the end of the day the government presented them with.
So it would have been open to the government to say, thank you for your letter, we insist upon the terms
Yes.
we've included.
Yes. No, well, the agreement, no, that of course would contradict the agreement, my lord. The agreement was that they have a development agreement referable to 35 acres. But the terms of the development agreement, apart from the extent of the land and the location of the land, there's nothing else in the agreement. But location and extent are in the agreement. And that's why this case is different from a commercial deal where the parties negotiate the details of the agreement. This is akin, if you will, to an agreement where to take an extreme example, a council tenant is given a council flat. There's no question that the council tenant who is allocated a council flat will be able to negotiate the terms.
Well, he couldn't carry out a review, but on page 264, that was the very thing which the promoters were going to be allowed to do.
Well, it depends, yes, my lord's right. It depends whether one reads the word review as meaning negotiate, or whether one reads the word review as make sure it's not incorrect, that it's the, so for example, that the location is correct, that the acreage is correct, that it is referable to the project proposal that you've been obliged to provide us with. Matters of that sort, the identity of
We know that review is a fairly wide description, don't we? Because it's also used in the penultimate paragraph on page 264, because the first thing that's to happen is that the detailed project proposal is to be submitted to TC Invest for review.
Yes.
And that, in that expression there must be quite a wide review. They could review the thing broadly and either accept it or not.
Yes. And
Well, why would you give review a different meaning in the second paragraph?
Well, it's the
Of the same letter. Of the same letter. Surely in each case, in the first case, TC Invest were to review the terms of the proposal, and that would no doubt be negotiated so far as necessary. Then the next stage, you get a draft agreement, and that is to be reviewed by the promoters, and there again the parties would discuss it, and they would or wouldn't reach an agreement. And when they did, then they'd have a binding agreement. That's essentially what the judge held. And speaking for myself, it seems to be difficult to gainsay that.
well, save, my lord, that it ignores what we say is the reality of the position that pertained here, that the government had the whip hand. So far as the government was concerned, the government was allotting development plots to identified developers, and the terms upon which the land was allotted would be determined by the government, as would the rental under a conditional purchase lease, and as would the purchase price. At the end of the day, when if there was an entitlement to purchase the freehold on the completion of the development, and so far as the development proposal is concerned, it's never been suggested that the work to be done on these sites was anything that was not in accordance with the wishes of the government. So that the reason that TC Invest was the government organisation tasked with facilitating the development of Crown lands, and was actively involved with reviewing, if you will, approving what developers propose to do.
Was the suggestion made by Mr. Simons in his letter of the 15th of October that they would pay the scholarship levy on a yearly basis, 1/10 of 1% of whatever the construction costs are for the applicable year? Was that an element of the review?
Yes.
It was an element of the review.
Yes.
Well, is that not a counter-proposal? Was it not a negotiation?
Yes, it was. It was a suggestion. But ultimately, my lord, if he had been told no, this is what will happen, then that is what he would be obliged to do.
3A1 for 1.1.4 scholarships, there are a lot of blanks in it.
Yes. At this, it's in response to 4.1.4 that Mr. Simons makes the proposal that my Lord Kerr has just referred to.
The fill in the blank.
Yes. He makes proposals as to the, it's the scholarships at 4.1.4. So he makes a proposal when reviewing that, which in the final version of the agreement would either be adopted by the government or not. These, of course, there were policies that determined all of these matters, so that the discount available to projects with belonger involvement were set out in policy terms, in policies. And similarly, there would be policies determining such matters as scholarships.
Which are left blank in the draft.
Yes. In this draft they are, yes. But in the final draft, of course, they would be inserted, but inserted, we say, not as a result of negotiation, but by the government in accordance with its policies. And that, again, was the evidence that the learned judge heard. Effectively standard form agreements with the details supplied by policy.
Why does Mr. Simons make a proposal then? If this was predetermined.
Well, there is nothing to prevent him from doing that, my lord. He can indicate a proposal, but the point is that ultimately, if the proposal is rejected, the partners are stuck with it.
But if I've understood you correctly, it's bound to be rejected if it doesn't accord with the relevant policy.
I don't know. I don't know. We don't have the relevant policy. I don't know whether there was an element of discretion accorded to the government insofar as scholarships are concerned.
Yes, thank you.
Well, subject to what my colleagues have to say, I think we've probably got the argument on the existence of a contract, which, if I've understood you correctly, is that a contract came into existence on the receipt by the government or TC Invest of Mr. Simon's letter of the 15th of October.
Oh, that's right.
Because, as I understand it, you say that after that, well, everything was complete because you have a standard form of development agreement, standard form of lease.
Yes.
And there's nothing more to be agreed.
There's nothing. No, that's right, my lord. That the gaps are supplied by policy, and are effectively at the diktat of the government.
Yeah. Well, I don't take you much away, but on that basis, what about your alternative argument, has to proceed on the basis that you're wrong on the first point, and that the parties never got to the stage of making a concluded bargain.
Yes.
How do you got the alternative way in your case?
The proprietary estoppel point, my lord. Yes. Well, there was no dispute between the parties. Certainly not, and not at trial. And it was certainly, there was a clear finding by the trial judge that both parties intended to be bound by this arrangement. And it's that intention to be bound that informs the proprietary estoppel argument, that the parties intending to be contractually bound on the basis of the representation contained in the offer letter that a development agreement and a conditional purchase lease would be forthcoming, that the partners acted to their detriment. They expended money on the survey. They expended money on the drafting of the detailed project proposal. And as we've seen through looking at the amount of time this took and the amount of work that it generated, they invested time and effort on the proposal. And we say that in those circumstances, the government should be estopped from acting unconscionably and resiling from the promise contained in the offer letter.
Start negotiating with somebody for some contract, some agreement for property, take a lease or buy property and so on, and you get the situation where both the seller and the buyer, or the lessor and the lessee, are very anxious to make a deal, hope they can make a deal, have every intention of making a deal. But something goes wrong. They can't in the end agree. But the estoppel doesn't arise then. This happens every day of the week.
No, it's if they intend to be bound and believe themselves to be bound, and on the basis of that, one acts to his detriment on the faith of the promises, the assurances given by the other.
So it's a necessary part of this way of putting your case that both parties believed they were bound.
Yes.
Yes. When do you say they both had that state of belief?
They both had that state of belief on the receipt of the offer letter.
Was a finding to that effect made?
Yes.
That they believed themselves to be bound,
Yes,
as opposed to intending to be bound?
The finding was that they intended to be bound.
That's different, isn't it?
The evidence was that they believed themselves bound. Perhaps I'd better, my lords, if one goes to the judgment of first instance, it's paragraph 41 of the judgment of the learned trial judge, page 1041, my lord. That's in the file 3. At the conclusion of paragraph 41, the learned judge said the arrangement was undoubtedly intended to have legal effect. I must therefore see if it can be made to do so.
Yes, entirely clear to me what legal effect.
talking about subjective intent, is the judge. It must be.
His finding.
They agreed that it should have.
Yes, that they intended to make a contract, a binding contract, and their evidence was they thought they had done so.
But what they thought is neither here nor there, is it? We're only concerned with communications, are we not, across the line between the parties? And the judge may simply be referring, I don't know what he's referring to. He doesn't make it at all clear. He doesn't make any underlying findings of fact, does he, which leads to his conclusion there.
Well, my Lord, I apprehend the intention to create legal relations. That intention is a subjective intention. One finds it evidenced in what the parties did, but the intention must be a subjective matter.
Well, it's something deduced from communications between the parties.
Yes.
If I write myself a note which says I intend to do something, that's really irrelevant, isn't it? You can only deduce the intention from communications or from the circumstances, can't you?
Yes, but yes, but the parties' understanding and belief about what they were doing is not irrelevant. If, for example, everything they've done gives the appearance of a contract, but they both say, well, we didn't intend to be legally bound by any of this, I apprehend one wouldn't then say that they had created a binding contract.
Right.
I'm getting slightly lost here. What is the intention? Is it that the receipt of the letter of the 22nd of January, at that moment, both parties, as you say, intended, and this is where I'm afraid no doubt intended what? That they then got a bargain? That they would have a bargain? I'm not clear in my mind as to what the submission of this, bearing in mind that this submission was made on the basis that somewhere down the road of your first submission, there is no binding contract.
No, it's only if there isn't a binding contract that one then goes to the alternative argument that there is or should be a proprietary estoppel. So something short of a binding contract. But an intention to make.
What's the representation?
The representation is that contained in what we call the offer letter, that a development agreement and conditional purchase lease will be granted to the partners in respect of the 35 acres north of Amaniara. There's a...
While we have the judgment, does the judge refer to this idea of a standard form?
Yes. No.
In 44, paragraph 51 doesn't look like a standard form.
No, he was against he was against the partners on it, my lord.
So you haven't got any finding of fact from the judge that what was agreed that there would be a written agreement in a standard form?
No, I mean, it was he was with the developers on the question of the price, but he was against the developers on the question of the details to go into the development agreement. That is to say, he rejected their argument that was a standard matter. He said it's a matter for the parties to agree between themselves.
But anyway, there's no finding of fact that there was some sort of oral agreement that what was being agreed, or even understanding that what was being agreed was, quote, say, standard form. Is there?
No, there isn't. No, there isn't.
So you haven't got it in the documents, you haven't got it in the judgment.
No, you've got it.
Where have you got it?
Well, you've got it in the evidence that because the judge very helpfully produced fairly detailed note of the evidence that he heard. And this one goes to page 1061. If you please, my lord.